In Section 5.1, we learned that one of the most common causes of escrow delays is the discovery of liens, judgments, or title defects during the title search. In this section, we'll dive deeper into how these issues arise, what Arizona law requires to clear them, and how real estate professionals can assist their clients in navigating these obstacles ethically and efficiently. Understanding liens and their impact. A lien is a legal claim or charge on property used to secure the payment of a debt or obligation. Liens run with the land, meaning they remain attached to the property until they are satisfied or formally released, even if ownership changes. In Arizona, liens are typically recorded in the county recorder's office where the property is located under ARS Title 33, Chapter 7. Once recorded, they serve as constructive notice to all future purchasers, as defined in ARS Paragraph 33, 411A. Common types of liens affecting title include mortgage or deed of trust. Liens, ARS Paragraph 33-701. Mechanics and materialmen's liens, ARS Paragraph 33-981. Judgment liens, ARS Paragraph 33-961. Tax liens, ARS Paragraph 42-117-153. Child support liens, ARS Paragraph 25-516. HOA assessment liens, ARS Paragraph 33-1807 or Paragraph 33-1256 for condos. Each must be resolved or released before clear title can transfer. Example: a seller in Mesa had an old second mortgage that had been paid off 12 years ago but never reconveyed. The title report showed the lien still active. The title officer requested a deed of full release and reconveyance under ARS Paragraph 33-707, which requires a beneficiary, lender, to record the release within 30 days after satisfaction. Once recorded, the title cleared and the property could close. Judgments and garnishments. A judgment lien arises when a court enters a monetary judgment against an individual, which is then recorded to attach to real property. According to ARS, paragraph 33-964A, a judgment becomes a lien on all real property owned by the debtor in that county. Judgments are valid for 5 years from the date of entry, unless renewed under ARS, paragraph 12-1551. Even if a debtor pays off the judgment, it does not automatically disappear. It must be satisfied and released through the court. Example: a Phoenix homeowner had a paid credit card judgment from 2015 that was never formally released. The title company required a recorded satisfaction of judgment before issuing a clear title policy. The seller's agent coordinated with the creditor's attorney, and the release was recorded just days before close of escrow. Agents should remind sellers early in the listing process to disclose any judgments, bankruptcies, or court actions that might attach to title. This helps prevent last-minute delays or cancellation. Mechanics and materialmen's liens. Arizona's mechanics lien law under ARS, paragraph 33-981 through paragraph 33-108 allows contractors, subcontractors, and suppliers to file liens against property if they have not been paid for labor or materials used in construction. To be valid, a mechanics lien must: 1. Be recorded within 120 days after completion of the work, or 60 days if a notice of completion was recorded, and 2. Include a preliminary 20-day notice as required under ARS, paragraph 33-992.01. Unreleased mechanics liens often cause closing delays because the title insurer cannot issue a policy until proof of payment or a release is obtained. Example: in a Tucson new build closing, a subcontractor recorded a $7,800 lien against the property after not receiving payment from the general contractor. Escrow required a lien release or bond before closing. The builder's agent provided proof of payment, and the lien was cleared under ARS, paragraph 33-1004, which allows bonding over a lien. Agents representing buyers in new construction transactions should educate their clients about mechanics lien risks and verify that a notice of completion and all lien waivers are on file before COE. Tax and HOA liens. Property tax liens are automatically attached to every property as of January 1st each year under ARS, paragraph 42-117-153. These liens have superior priority, meaning they take precedence over most other liens, including mortgages. Escrow must collect and prorate taxes at closing to ensure payment. Homeowners Association, HOA, liens, governed by ARS, paragraph 33, 1807 for planned communities, and paragraph 33, 1256 for condominiums, secure unpaid assessments and may also include collection costs and attorney's fees. Title companies will require a resale demand and estoppel letter from the HOA showing all outstanding balances before KOE. Example: a Gilbert seller owed $2,400 in back HOA dues. Escrow deducted the amount from sale proceeds and sent payment directly to the association, ensuring the lien was released and the buyer received clean title. Clearing title defects. Beyond liens, title defects can include missing signatures, errors in legal descriptions, unreleased easements, or conflicting deeds. Title officers handle these issues by requiring corrective documents such as corrective deeds to fix minor errors, ARS, paragraph 33, 41101. Quitclaim, deeds to release potential ownership claims. Affidavits of heirship or affidavits of successor for deceased owners. Subordination agreements, when a lien holder agrees to lower lien priority. Agents play a supporting role by communicating promptly with clients and coordinating document signing, notarization, and delivery to escrow. The agent's role in legal boundaries. While agents are not responsible for clearing title defects, they must disclose any known issues that could affect ownership or marketability under R428-1101E. They also have a duty under R428-1101K to recommend legal or title professional advice when issues exceed their expertise. Agents can add tremendous value by reviewing the Schedule BI section of the title report early, alerting clients to unresolved liens or judgments, coordinating with escrow and title officers for document collection, keeping communication written and well documented. Example: a Glendale agent noticed an old easement for a telephone company listed in the title commitment. The buyer intended to add a detached garage. The agent flagged it for the title officer, who confirmed the easement was abandoned and recorded a release before COE, preventing a potential post-closing conflict. Key takeaways. Unreleased liens, judgments, and title defects are among the most common obstacles to closing in Arizona real estate. Every lien must be satisfied or released under ARS Title 33 before a title company can issue a clear policy. Agents should understand how to identify these issues in title reports, disclose them promptly, and collaborate with escrow and title officers for timely resolution while adhering to R428-1101E and R428-802A.